Yes, get ready and start.
Further, no interlocutory injunction can be granted unless it is in aid of a substantive relief, and therefore a suit simply praying for an injunction would also be liable to be rejected under Order 7 Rule 11 semicolon. No interim relief can be granted unless it is in aid of and ancillary to the main relief that may be available to the party on final determination of rights in a suit. Learned counsel refers to State of Odisha versus Madan Gopal in support of the submission semicolon. Such a suit would be really in the nature of a suit for interim relief pending an entirely different proceedings. Stop. It is settled law that by an interim order the court would not grant final relief. Stop. The nature of such a suit would be to grant a final order that would in fact be in the nature of an interim order. Stop. He submits that the intention of the Indian Parliament in enacting the Arbitration Act 1996 was not to leave a party remediless. Stop. Mr. Gopal Subramaniam submits that the issue in the present case is that in addition to the challenge to the validity of an award being made in courts where the seat is located are domestic courts excluded from exercising supervisory control by way of entertaining a challenge to an award. He submits that the issue arises when it is not possible in a given law of the place of arbitration. Stop. The Arbitration Act 1996 has removed such vagueness. Stop. The Arbitration Act 1996 clearly states that in respect of all subject matters over which courts of judicature have jurisdiction, the national courts will have residual jurisdiction in matters of challenge to the validity of an award or enforcement of an award. Stop. He reiterates the submissions made by other learned senior counsel and points out that the Arbitration Act 1996 is not seat centric. Stop this. According to learned senior counsel, is evident from numerous provisions contained in Part 1 and Part 2. Stop. He points out all the sections which have been noticed earlier. Stop. According to learned senior counsel, the definition of international commercial arbitration in section 21F is party centric. Stop. This definition is not indexed to the seat of arbitration. Stop. Similarly, the definition in section 21E is subject matter centric. Stop. According to him, there is a crucial distinction between the definition of international arbitration in the model law and the definition of international commercial arbitration under the 1961 Act. Full stop.